Well, hello everybody. Welcome to the NEC4 webinar series, which is entitled The Good, the Bad and the Ugly. Now, you'll find out why shortly. I'm John Lake, Chair of the APM Contracts and Procurement's Specific Interest Group, or SIG, and I'm pleased to be hosting today's event. As you may have read on the flyer, my background is in technology, now widely known as IT, and my CMP knowledge is largely from experience delivering contracts in many organizations. But I'm just the host today on the webinar, and the webinar itself is being given by Dr. Jon Broome, who I'll introduce shortly. Briefly about our SIG, the CMP SIG, our overall objective is to promote and disseminate knowledge, understanding and best practice of contracts and procurement in a project and program environment. We provide an ongoing forum for best practice. We draw on and disseminate the experience of others to help project managers. We provide specific guides and publications for contracts and procurement, particularly, of course, in the project and program environment. And our long-term aspiration is to become an international forum at the leading edge of excellence in contracts and procurement for projects and programs. So this webinar today is about the big picture of NEC4, and there will be a part 2 event which will be recorded, and that will cover changes to the engineering and construction contract section. That will be available on YouTube later. So I'd now like to introduce Dr. Jon Broome, who has been involved with the NEC from the beginning over 25 years ago, and is also the ex-chair of the Contracts and Procurement SIG. John will tell you a little bit about himself in his presentation. So I'll hand you over now to John.
Thanks, John. What's the objectives of this? For both parts 1 and 2, to identify and review the changes made from NEC3, the 3rd edition of the family of contracts, to the 4th, as well as highlighting changes that have not been made. So changes that I would perhaps, others would like to have seen, and to express an opinion. So this is an opinionated piece, as anybody who knows me probably knows me as being fairly opinionated on what is good, and that's most of the changes. What is bad, which is really could do better. So it's things they haven't done, it's things where they've tweaked it, and I thought, well, actually, I can see a flaw in that. And the ugly, which is a few clangers the drafters have dropped in my and others' opinion, it seems, as well. Part 1 focuses on the contract strategy changes. So it's the new members of the family, the new or dropping of a main option, and new secondary options or change secondary options. And that includes the dispute clauses. This is really, I suppose, suitable for people who have an awareness and upwards of the contract. Whereas part 2 is perhaps for those who have more of a working knowledge of the engineering construction contract or other members of the family. There are, as we will see later, quite a few members of the family. The original, the big beast of the family was the engineering construction contract, and many of the changes which have been made to that are spread throughout the rest of the contract or the contract family. Agenda for part 1, a very little bit about me, a quick overview of the NEC's original objectives, what they publicly said they were trying to achieve for the 4th edition, 2 very quick changes in terminology which apply across the family. What are the new members, the changed members of the family of contracts? What changes have they made to the main payment options? And that's pretty brief because they've made 1, which I'm covering. Changes to the W dispute options. So they've added a new dispute option, but there's also some tweaks they've made to the existing ones, and then quite a few changes to the secondary options. Hopefully we're going to have some questions after, I think it's changes to the main payment options. And then we'll finish off, and this perhaps we'll look at the time, but with some other changes across the family. Very little bit about me. I'm a genuine NEC geek, as in I've been involved in its development since 1993. when I studied, got my PhD researching it when it had just come out under one of the co-instigators, the original 2 co-instigators of the NEC. So involvement goes back 20 plus years. My contributions were in the 2nd and 3rd editions of the engineering construction contract were acknowledged. I authored the top-selling NEC3 users guide, which is also, last time I looked, I'm top-selling. I'm told it is the top-selling book on NEC3. It's also, I know, because I'm vain enough to compare, it's the one which is the top-rated on Amazon. And I also led with other members of the SIG, in collaboration with Thomas Telford Publishing, who publish it, the NEC3 Professional Services Short Contract with other members of the Contracts and Procurement SIG. So big up to Steve and Alistair if you're still listening. I wasn't involved in the 4th edition. And you might ask why. Well, the answer is I don't know why, but absolutely. There's a little bit of feedback that I was challenging to work with for the Professional Services Short Contract. I view challenge as good, and I think at the end, certainly the 2nd one, we might say a little bit more challenge would have been good. I also helped co-author a rival product in terms of e-learning, but you'd have to ask the actual people, the drafters, why I wasn't involved. Just a little bit of housekeeping. NEC3 and NEC4 are registered trademarks of ICE Publishing, who publish the contract. I'm not, in terms of clients that I have on and off and so on, there's this slide. The ones, if I go up here, are big clients, big contractors here, smaller contractors here, training organisations here, and I've in the past worked through EY, and MPS are an NEC cloud-based supplier. So I do a fair amount of industry stuff, or that's how I earn my living, basically. That's how I pay the mortgage. Moving on. So NEC3's original objectives were to have these 3 things, and I will say a bit more about them just to bring people up to speed. So flexibility. There we've got a nice little baby, very flexible. What's the purpose of having a flexible contract? The idea is that it's easy to select, much easier to select the best fit contract and contracting strategy for the packages. So I'm using in the new Contracts and Procurement Guide terminology, a package is a contract which is let out for the package circumstances without having to rewrite stuff, start from scratch, cross out a standard form, etc. So there is a whole family of interlocking contracts for works, physical works, goods, the supply of goods which could be bespoke to your project, and for services. Okay. Across the whole family, with the exception of the framework contract and the dispute resolution contract, there is a similar structure and terminology across the whole family. That is bad news for someone like me who does training on the NEC, because it means that if you ask me to do 2 days training, one on this member of the family and one on another, I'm going to be saying 50% of the same thing. So I get less work. It's good news for other organizations who use it, because you can use the same processes across your whole portfolio of projects. And for contractors in particular, it provides back-to-back contractual cover, so they can pass risk and obligations and remedies down the contractual line, which should mean it's a better managed project. In the long form, so we will see in a few moments, there's short and which have short in the title. And when I say long, they don't have long in the title, they just don't have short. There is a modular structure so that you can adopt a pick and mix approach to assemble the best fit commercial arrangement for your project, your package, for the individual package, without expensive legal input. There's numerous other aspects of flexibility. In the engineering construction contract, which are put in black, ECC, any extent of contract design, and you can alter testing requirements. You can do numerous things in terms of flexibility. Clarity and simplicity. Well, why clarity and simplicity? The hypothesis from the original instigators was a lot of disputes start because people don't understand the contract. They're either hard to find what you're looking for, and or when you find it, it's in legal gobbledygook. So you go, oh, I just won't bother looking at the contract. And that's fine if everything works out, but then if both parties especially aren't following the contract, you can just end up with a big ball of spaghetti to unwind, as well as an unsuccessful contract because people haven't been doing what they should have been done. So simple and common structure across the whole family. They flowcharted them as a check on logic to make sure they're consistent. That picked up a lot of errors. It also hints at the process of project management embedded within the contract procedures. They use shorter sentence lengths, trying not to get sentences of over 40 words. That was the original directive. There are a few, but by and large, they've either broken them into 2 sentences or used bullet points, because the way in which the human mind, the visual system works, you can absorb exactly the same sentence, but with bullet points. And they try and have less subjectivity. And notice I'm not saying no subjectivity because we're using English. So preciser definitions or defined terms, preciser roles and responsibilities, who does what by when, preciser risk allocation, as in what is an extra, what is a claim and variation, preciser rules for assessing the quantum of compensation events. So as I put a little reminder, claims and variations in old speak. And it's also about a third of the length of traditional contracts. So there's much more brevity. And some commentators have said that brevity, that plain English, can lull people into going, oh, it's just plain English, it's easy, without contemplating, becoming aware of the full implications of the clauses. And in terms of the stimulus to good project management, it was actually the original objective was stimulus to good management. But seeing as the 2 founders, my professor and John Perry and Martin Barnes, well, Martin Barnes co-founded the Association for Project Management. Both were fellows. Martin was an ex-president. I think it's fair to say it's good project management. So what's the high-level objective there? A range of contractual mechanisms and incentives, and the incentive bit is the stimulus bit. So pokes in the prod, it pokes in the eye, prods in the ribs to get people to do the things in the contract, to promote collaborative project management, thereby increasing the likelihood, the predictability of time, cost, and quality objectives being achieved. So how do they do it? There's a strong emphasis on a detailed, updated, agreed program. It's stated in more detail than other forms of contract. It's updated regularly. There's an early warning process for early warning of issues. There's more defined criteria and process for rapid resolution of time and cost effects of compensation events, so claims and variations. Believe it or not, stating the bleeding obvious, this is where most disputes happen. Is it a claim or a compensation event in NEC speak? And how is it assessed in terms of quantum, time, and cost? Well, if you can nail that contractually, then you've overcome potentially a major source of dispute or disagreement. And all the time that people are focusing on the money and the extra time, they're not actually focusing on actually solving the issues which are causing that. All actions do have a timescale attached to them, often with a sanction or stimulus if not done. And within the engineering construction contract, you have a project manager, a supervisor, and adjudicator. So the adjudicator, an impartial arbiter of disputes within a set timescales, supervisor responsible for checking of quality, and the project manager who really has 2 roles, an impartial administrator in certain circumstances, but also there to represent the employer's best interest in other circumstances. What were the objectives for the 4th edition? So if I won't go through them, well, obviously the last one relates to the stimulus to good project management. They wanted to boost that. The top 2, I think you could say, relate to flexibility. So new markets, new sectors. One of our briefs when we did the professional services short contract was to try and expand out of the traditional construction and heavy engineering markets. That was one of the things which led to a change in terminology from the employer to the client. But markets could be overseas as well, and international use. And also support new approaches to procurement. You can say that relates to some of the secondary options which are that, and new members of the family. So let's see how they've achieved those or whether they've achieved those. So before we do that, context of the comments. Here's a quote from Aristotle, 2,500 years ago. I'm very aware that this is a critique, that I wasn't involved. So please put my comments in context. Most of what has changed is good, in my opinion, and that is a good changes to what was already a good contract in terms of the competitors, the competition, FIDIC and JCT. For me, NEC is way ahead in promoting collaboration and good project management. It's written in plainer English already, and it's more flexible. So these, if you like, increase the distance from those. So any negative comments, do put those in that context. So 2 changes in terminology across the family. One is the employer becomes the client, as that's more commonly accepted across sectors. So when we did the professional services short contract 2013, Alistair and Steve had worked in the health sectors and the oil sectors, and they were going, who the hell is this employer person? We don't know that. So we changed it to the client. That's been adopted across the family. The other change across the family is that you had works information, service info in the engineering construction contracts, you had service information in the term service contracts, goods information in the supply contracts, and scope in the professional services contracts. And basically it all said, works information specifies and describes the works and states any constraints on how the contract is to provide it. Service information said pretty much the same thing, except you had service in there. Goods information said about the service. It's all become scope. Now, initially, I was a bit, I've been used to 20 plus years of works information, service information. But actually, the more I think about it, the more I think that's probably good, because it means that if I'm a main contractor and I'm having to subcontract out, for instance, design, I don't need to put in a little statement which says, when I've cherry picked out stuff and put it in a sub package to subcontract out the design, I don't need to change the terminology or write a generic statement, say, when you read works information, I actually mean scope. So both of those things, good changes. Okay. Then let's look at the NEC family of contracts. So here they all are, crikey. I have highlighted the new ones, and I'm pointing at them now, down there, and you've got a newly named one there. And I've tried to use the colours that the different contracts are coloured in. The one that which isn't in there is the alliance contract, because that's not actually published in a hard form yet. It's in a consultative form, which can be downloaded from the website. So if we go, if I hide that, if we go on to them. So changes to the 2 good changes, 2 new subcontracts. The professional services subcontract and the term services subcontract, the full forms, as in if I go back one, they haven't got short in the title, there are subcontracts to those. So they are back-to-back as you can get. The only things which will change are the client becomes the contractor or the consultant, and the contractor or the consultant becomes the sub-consultant. Exactly the same processes, etc., but timescales for response will be slightly tweaked. So if a communication has to go down the line and then back up, the sub-consultant, for instance, would be able to has to respond within timescales to enable the consultant to respond to the service manager within the timescales of the main contract. So those are good. What I would actually like to have seen, though, is compatible short versions for these contracts. Now, legally, when I say compatible, if they were fully legally compatible, they'd be the full contracts. But one of the things I commonly see is that full contracts are used as subcontracts on simple contracts, basically, where with all the full project management, emphasis on programming, risk management, etc., etc. And you just go, are people really going to do that? And the answer is no. And that applies both to I'll revert to well, the consultant or the contractor under the term service contract, as well as the subcontractor. And what happens is both parties end up in breach, and that's fine while it works and the project's been delivered successfully. But then when it isn't, you end up with a big ball of spaghetti to unwind. So I would like to have seen subcontracts with compatible timescales, etc., to the main contracts. So, I should also say, you might notice that the could do better is not bad. The good, the could do better, and the ugly isn't quite as catchy a title. So really, when I say bad, I really mean could do better. Okay. The good is that they've got a design, build, operate contract out, which has got the same structure as the others. Now, what people were doing occasionally before was they were saying, okay, I want to get a consortia normally in, and I want them, and I've got a sort of an idea, but there might be varying levels of design, which would be under the professional services contract, or could be under the professional services contract, various levels of build. The engineering construction contract in black can have contractor design, so it could be that the design is within there, but it doesn't really cover operate. So whether it's 3 or 2 contracts, I've got to somehow weld them together with an overarching agreement, and then I've got to look at these individual contracts and take out and tweak clauses, etc., so it all fits together. So what they have done is they've effectively merged them into one contract. So you can have a DBO contract, design, build, operate. It is not, as written, a DBFO, design, build, finance, operate contract, which is more popularly known as a PFI, or private finance initiative contract. However, having said that, if I was a client and I made it clear to my tendering contractors, I am not going to pay you anything until you start operating it, then that consortia of contractors or the individual contractor might go, right, well, I need to approach a bank to get a loan to finance the design and building of it before I start operating it. And effectively, in simple terms, it does become a design, build, operate contract. More realistically, what the DBFO contracts that I've seen are an absolute nightmare, led by finance people who then write the DBO bit, which they don't know much about, and it's an absolute nightmare. People have just put that bit in the drawer and said, if we get this out, then we'd just be in dispute, so we'll just work our way through it. What this gives is you can actually say, okay, you finance people, you write the finance bit, and we've got this DBO contract bit, which suits how we work, matches how we work, and it's commonly understood. And you can let the finance people do that bit and add them together with the overarching bit. So I think that's a really, really positive development. So next one is they've added an alliance contract. Now, what the hell is an alliance? So look here, so an alliance, the number one character of an alliance is that commercial objectives are aligned to the success of the overall project rather than people's individual contracts. So just as a little bit here, the blue box represents the people in the alliance. Now, there are actually 3 forms of alliancing out there, 3 generic archetypes, if you like. So they actually already covered one, and I would call it a simple alliance. And it was enacted under NEC 3, and now it's still under NEC 4 through option X12. It was called the partnering option in NEC 3. It's now called the multi-party collaboration option. And what happens is, and I'll go back, is you have individual contracts between the client and the consultants and the key suppliers. And these individual contracts have option X12 added onto them. So there is no contract between these people across here. What those X12 clauses cover in pretty much the same way is the core group, which is effectively a board for the project, partnering information, which is about how the parties are going to work together, so the structure, the common IT systems, things like that, and key performance indicators against which positive only incentives can be set. So if my project comes in below £10 million, the designer gets 10%, Contractor 1 gets 25%, Contractor 2 gets 25%, leaving me as a client with 40%. Okay, and that could be for time, it could be performance, etc. The actual core clauses, the Clause 12 clauses, also cover at a high level early warnings between other parties, joint timetable for the program, and compensation events for changes to the partnering information. And it is the easiest form of alliance to put in place, because basically you're saying, yeah, I'm only offering you upside, and who would turn that down, and you're not having a multi-party contract. The new contract is an alliancing contract, and it's been termed out there as the Pure Alliance, or the Australian Alliance, where they've had a lot of success in Australia, although independent academic research has basically said the alliance is often target is set too high. This is one multi-party contract which all parties sign at the same time. It's very similar in structure to other members of the family. It does cover joint downside liability. So if my project comes in late or over budget, you will take a share. All partners sign the same contract at the same time. And this is the hard bit, because if you go going a contract round the houses to legal departments, you know, everyone wants to make a change, and then it's got to do the circuit again for everybody to be happy. And technically, in terms of the scope for everybody, you're doing this bit, has to be there at the same time. So I do know alliances which have been entered into, but actually no one signed the contract, and if they didn't work, everybody would be going, well, which contract did we sign at the point of entering into the contract? Having said that, it does allow for two-stage engagement, where stage one is on a cost-plus basis. So consultants, you work as consultants to get to a stage where everybody's happy, and then stage two is the implementation, and that's where pay and gain is. It's also the hardest form of alliance to get one party out, because everybody signed the same contract, and you've got to dissolve the whole alliance, which also means that you also dissolve the whole work scope as well. So it's good that this is here. It's good that this is here. What I would have liked was actually the traditional alliance. And this is where all alliance members have a traditional works and service contract under one of the NEC family. They're usually cost-based, but not always. So, for instance, suppliers of critical components which are manufactured in a factory, it's a nightmare to reimburse on a cost-plus basis, because what was incurred on delivering that order for delivering another one. So it allows more fit-for-purpose commercial arrangements for the individual suppliers. And then an extra contract is added on top, which ties the fortunes, good and bad, of people to the overall project. The advantage of that is easier to add members as the individual scope for those packages reaches maturity, and it's easier to get rid of an underperforming one partner is underperforming, because you can effectively kick them out of the alliance but still keep the work scope, or alternatively just kick them out altogether through the termination procedures. There's no NEC4 traditional alliancing contract. I think I prefer that to the pure alliance. So I quickly go on to changes to the main payments options. Then the professional service contract, which has dropped an S from the services, has lost the option G term contract. So this is very relevant at the moment, because one of my clients maintains the M25. They have a number of consultancy agreements which at their lowest level are just monitor this asset, monitor the Queen Elizabeth Bridge, and based on what the monitoring something, add in an extra task order. Well, they've got rid of the term contract, the option G term contract, so you can't do that. So what we're probably going to do is basically take the NEC3 wording and update it to be compatible with the NEC4 professional service contract. So this is a sort of ugly, bad stroke ugly, to be honest. I don't see the logic for getting rid of it when there's clearly a need. Their response is, well, okay, you could use the term service contract for this. That needs an effective property. The insurer, you're providing physical works in terms of repairs, etc. So the term service contract would need numerous tweaks to make it suitable. So I just think that's a bad stroke ugly. It's not a real ugly, it's just a bad stroke ugly. Changes to the W options, the dispute options. NEC3 has W1 and W2 for adjudication, so a cheaper, simpler, less proceduralised form of independent dispute resolution done within a set time scale. Normally a month, can be extended to 6 weeks. W2 complies with the UK Construction Act, where you have to be able to refer at any time, and W1 is for the rest. In NEC4, they've added in this a senior representative resolution. So basically, if the site team is getting stuck, it can be referred to senior representatives who are outside the day-to-day, possibly the week-to-week of the contract, and they try and sort out the dispute and resolve it. They can get more of the root cause. Is it because actually we're having management problems, etc., rather than if you go down the more legal route. In W1, it is mandatory, but in W2, it can't be because it's subject to the UK Construction Act, and it isn't. Okay, so it's optional under W2. They have also added in, new to NEC4, is W3, which is a dispute avoidance board. This is where 1 or 3 experienced people are appointed and who keep in touch with the contract periodically. So they can periodically visit the contract. If a potential dispute arises, and the ideal is they nip them in the bud, they head them off, they try to help them resolve it by whatever means they see fit. Getting people in a room, making suggestions, getting people to reflect. If that doesn't help, they can make a recommendation. And parties have to refer a dispute to it, or a potential dispute to it, more precisely, before going on to adjudication. As a result of that, it's not compliant with the Construction Act, so it's not compliant with the UK Act. And they actually say not to be used in the UK with construction, what are deemed as construction contracts. So what's my view on this? Well, actually, I think it's very good to have this. It might be more suitable for larger projects, but it's very good to have it. Having said that, I think it could be easily tweaked as W4 to be UK compliant, where this is an option, if you like, where you encourage, as they do with W2 for senior representatives, people to go through it. So that's a could do better. It would take minimal, literally 1 or 2 tweakings to a clause, using words from W2 to encourage that before you go to adjudication.
I've got a couple of questions here that have come in. The question I had while we're assessing those, they're a little bit late coming in, is the NEC contract, from my understanding, is that it comes from the construction industry originally.
Yeah.
So can you comment at all on how do you have to make any changes for it to be used, for example, in the IT sector?
Yeah, well, so first of all, if you were using in the IT sector for professional services, so you're hiring consultants, you would have to make absolutely no changes to the professional services contracts because they're for professional services. The only thing that would be different would be the scope. So you write in the IT scope, etc. If you were to use it as a service agreement, you would probably need to do a few tweaks to the term service contract in terms of a level of service that you're providing.
Yes.
So uptime, whatever it is, whatever you IT people talk about. I've actually done IT projects, but and actually, given I would say that on that it has been used for IT-based projects.
Yes.
Where, okay, a little bit of hardware has to be installed, but essentially it's about creating software and connecting up the hardware for monitoring and remote interventions.
Yes.
So it's perfectly suitable.
So it's been proved to be suitable.
Yeah. My general experience is that when you go in and you talk to people who are in the different sectors, they go, oh, I don't think it can do this. Oh, no. And you sit down, you explain it, and you talk about the terminology, and they go, oh, actually, this is good because I can now do this without having to do all that. So the flexibility in there, it's just in different language.
And do you think this will continue in the next series? I believe there's an NEC5 on the way.
Oh, no, that must be 10 years, something like that.
Oh, it's a little way away. Okay, so from David, what was the rationale for dropping PSC option G?
The answer is, as I wasn't involved in the development of NEC4, you would have to ask them. I think the stock answer is, oh, it can be done through the term service contract. which, as I said, I think, haven't gone through it in a huge amount of detail. I've done big assignments. I've put in, for instance, did one contract for £500 million worth of smart meters. I think that unless they, and this is from people who've been involved in the drafting, have commented, that was perhaps a little bit of a wrong decision.
Okay, so we got another question here from Milad. How about the oil and gas sector? Could you elaborate at all on that?
Yeah, I mean, it has been used a little bit in the oil and gas sector on Shell projects, I think, or Shell have used it from memory. There is absolutely, in my opinion, absolutely no reason why it couldn't be used in the oil and gas sector. You would have a scope. It would be what you've got to do. If you had a site, if you like, an area, that would be the engineering construction contract. If it was manufacturing some big stuff, that would be the supply contract. So there's absolutely no reason why it can be used in the oil and gas. The only reason would be the same reasons as when it was introduced into the civils and then went into the building and then went into the power sector and the water sector. It would be, oh, that's not how our terminology. It would just be a little bit of education.
Okay. In that case, thanks everyone for the questions. We'll have another session near the end.
Yep.
So, John, if you'd like to carry on with your part 2 of this.
Okay, I will do. So, changes to the X clauses. So, X clauses are the secondary options. And what you do is, having chosen a main payment option, you then have this menu of secondary options to choose from and fine-tune your contract strategy. And because they're pre-written by the drafters, they should, in theory, be perfect or better than having a lawyer bespoke them. And certainly that's my experience when I see lawyers trying to bespoke stuff. So what have we got? We've got X8 has changed from undertakings to the client and others. So it previously was not in the engineering construction contract and was collateral warranties. And people were saying, hang on, collateral warranties, why aren't they in the main engineering construction contract? They apply equally. So I like the fact that it's undertakings to the client and others, because collateral warranties are a subset of that. So this can be other undertakings, other warranties, which are offered, not just collateral warranties. And I like that it's in the engineering construction contract and term services contract, and therefore you're either not nicking clauses from the professional services contract and tweaking them, or lawyers aren't writing it a bespoke form. So that's a good one. I like there's a new X9 transfer of rights in the engineering construction contract, which mimics what was already in the NEC3 professional services contract. And this is basically where, without this option, if the contractor is designing something, they have the rights to use that elsewhere, and the client has the right to use it for their project. If you specify option X9, then basically the copyright, the intellectual property in what's been developed transfers to the client, and the contractor can't use it elsewhere. There's a new X10, which is called information modeling, and it replaces employer's agent in the NEC3 professional services contract. Now, first of all, in the professional services contract, you used to have an employer's agent who effectively did the role of the project manager in the engineering construction contract, the service manager in the term service contract. NEC4 professional services contract now has a service manager. People did say, why is it not called building information modeling? Because that's the terminology used in the construction industry for BIM. Information modeling has a broader application. It's not just building. And again, that reflects the more multidiscipline, the new sector emphasis of it. And the other reason why I like it was that actually they did produce a guidance note on the use of BIM with NEC3, but it was absolutely vapid. Really, there was no meaningful content in it. It just referred people to what's called the BIM protocol, which is a set of add-on clauses, and expressed a few concerns. Now, I actually wrote an article on the BIM using the BIM protocol with NEC3, and I described it as a contractual car crash waiting to happen. There is absolutely no way I could recommend any client use the BIM3 protocol with the NEC3. It covered the things, but not in a contractually compatible way. So I really like the fact that there is an X10 information modeling option now, and people aren't inventing or adding on the BIM3 protocol. So, and I haven't checked it through in detail, but from my memory of what were the key points that needed to, it's in there. I haven't spotted anything which stands out and makes me go in there. So all this is good. Other changes. There's a change to the X15 contractor's design. So previously, the engineering construction always allowed for any extent of contractor design, but the previous, with a funny P, X15, only limited the contractor's liability down to reasonable skill and care, as in, because contractors in construction, civil engineering, or consultants, I should say, can't get fit-for-purpose insurance cover. So this reduced a contractor's liability, who might be subcontracting, probably would be subcontracting out the design, to the same level as that of their consultants. So it limited it down there, and correction of a defect which was in the gap between reasonable skill and care and fitness for purpose was due to design was also a compensation event. So X15 now does the above and covers professional indemnity insurance. So previously, an amendment you had to make as an option Z clause, an additional clause, was to put in a little table to cover professional indemnity insurance that you wanted the contractor to have. You've now got that. The wording is slightly tweaked to that which is the insurance industry is comfortable with. So it's still reasonable skill and care, I think, to the same level of the average professional rather than the previous wording. It also changes the burden of proof to prove that the contractor hasn't used it onto the client, as opposed to the contractor to demonstrate that they have used it. So that goes a little bit against the client's interest, but it's a normal thing in law, is if you're going to sue someone, the burden of proof is on you to prove it. It covers IP ownership of material, the design or whatever generated, and the period that the contractor, has to retain that material. So I think that is all good. That's good. It stops people having to write extra stuff. It's thorough. I like it. What I would have liked, though, would have similar X provisions, similar, perhaps a little bit simplified, for the engineering construction short contract and the engineering construction short subcontract. Now, why do I say that? Other families, JCT, have an intermediate contract. So we've got a short contract, which is for very simple, low complexity work, full contract with full project management stuff, etc. in there. What I see is people either using the full contract with a little bit of design, and that's the only bit you need. So in theory, they should be doing all the other stuff as well, and in reality, they don't. Or I see the short contract being used when there's design, and it doesn't really accommodate design. It's got fit for purpose liability, doesn't really cover it. So I would like just as a set of add-on clauses for simple design, simple projects with simple design. So that could be relevant to me. My wife wants an attic extension. We already have an attic extension, but she wants a better attic extension. So that could be one there. It could also apply to specialist subcontractors who perhaps have their own specialist systems and ways of doing things, and they want that to do to the design there as a subcontract. So for that, for me, it could have done better in there. Other changes to the X clauses. So inclusion of X22, early contractor involvement. So this was November 2015, I think it was. They published an addendum for early contractor involvement. So this is where you work with the contractor to develop the scope to meet a price, and then it's converted effectively into a target cost contract where there's pay and gain around it. Also coming in the construction industry is the project bank accounts to help ensure faster payment down the supply chain. That was, I think it was incorporated into the April 2013 tweaks. Again, that's now in the contract. There's a new 21, which is for whole life costs. So if the contractor comes up with, proposes an idea which reduces the whole life cost of the asset, so makes it cheaper to maintain, might increase the capital price, they can get a share of the whole life savings. Having said that, and all this is good, I like this, like the previous slide, it's good. Having said that, with the whole life cost savings, I would like to have seen the proportion stated in the contract data. So at the moment, the contractor says, I've come up with an idea, please give me 30% of that. I would actually like to have seen it as a whole life value clause. So you could say value is benefit over whole life costs. So an estimate of this improves the functionality of it. Now on performance specs, you could very relatively easily put a figure to that, yeah? So if we do this, you would get a better asset. Can I have a share of that? More complicated clauses, but only one or two clauses to put that in. And this is what I've seen elsewhere. What happens if the project manager stroke client steals a similar idea? So initially they say, no. And then they go away and think about it. And 3 months later, they have a great idea, which bears a remarkable similarity to the original idea. And I've seen that under target cost contracts in the capital for savings and capital costs. So I would just like that to be a bit more fleshed out, basically, a few more clauses, and really perhaps more in line with project management thinking, benefits and impacts and so on in there. Other changes to the X clauses. There's no change to the price adjustment for inflation clause. I think that's unfortunate because it is, in my experience, when that's used, it's almost universally amended to set periods when the prices are changed due to inflation, as in on an annual basis. At the moment, you update the prices whenever an indices changes. Now that could be 6, 7, 8, 9, 10 times a year. So each month you'd have to be changing the prices to reflect inflation in the change in the indices. So other change, ultimate holding parent company has been changed from parent company guarantee. The thing about ultimate holding companies is that they could be offshore, hard to get to companies. So by the time you actually get to the company in Bermuda, this is topical, isn't it? Or wherever, actually the money's been taken out of it. Better to have one you can get to, which is, if you like, the ultimate UK holding company. And the wording doesn't quite reflect that. It is within the clause, it's the ultimate holding company guarantee. Minor tweak, but there we go. Also, limitation of liability. So this places caps on the total liability of the contractor to, for instance, damage to property, consequential loss, etc. And it has a total liability cap as well. But actually, that total liability has 4 types of damages or negative incentives which are excluded from it. So delay damages for time, share of pain and gain, then 2 others which I can't remember off the top of my head. But basically, it's not really a total liability, is it? And people are fooled into that. They read, oh, the total liability is this, and they read the clause. There's 4 exclusions from that. And the early in contractor involvement, I did a review of it. I think it's good. My one real concern is that if I decide not to proceed from stage 1, the consultancy bit, to stage 2, there is no termination. Now, there are some counter arguments to that. So, yes, but, and therefore, both what the contractor is entitled to in terms of money is potentially up at odds, but also if I decide to give it, we can't agree a price with that contractor, but I want to give it to another contractor. Well, actually, if the definition of the works is I want you to work with us to design and develop it and then construct this asset, and I haven't actually terminated that contract, then the contractor who had it originally could say, actually, legally, you're not allowed to give it to that other one until you terminate. And that would mean that actually it would be terminating it for any other reason. And that could be quite expensive, depending upon what's in the actual, the scope. So I would just like, and I've done it on ones which I've developed, you just add in a few extra clauses which fit in with the existing termination clauses to make it clean. So that all this could do better. So very briefly, some other changes to the across the family. There is now a schedule of cost components for all the long forms. That's good. I have a few reservations on calculating people under the professional services contract. That basically relates to previously the consultants would say, here's my rate. Now you calculate it from first principles, and how consultants will view that might be problematic. How partners and people like me who are essentially self-employed and as my consultant with my account would say tax efficient, so I pay myself a minimal salary, means that I probably wouldn't work under the professional services contract if my fees were going to be calculated on that basis. Likewise, a partner for a big firm might refuse to work on it. The schedule includes subcontractor costs, and they're added in there. That has some ramifications, which I'll consider in more detail next time, but that's good. There's tidying up of the subcontractor definition to exclude labour only and agency staff, along with other changes that I've had been involved in disputes which have been over millions of pounds on involving that definition. So that's a good one. Basically, it is are labour only agency staff? Well, if you looked at the old definition of subcontractor, they are, but how in that schedule of cost components of the box, at the top of the page, they were considered as a people cost. So which one are they? It caused confusion and argument. There is Section 8 is now liabilities and insurance versus risk and insurance, which is reflective of what it covers. So risk is a sort of too generic a term. It's liabilities and insurance. So that's good. So all this is good. But what they have done is, rather than saying everything, and I'll use NEC4 terminology, rather than listing out the client's liabilities, which are a subset of compensation events, what they've done is they've said, as they did effectively in the NEC3, and then basically said, and anything else is a contractor's liability. What they've done is they've listed out the client's liabilities, and then they've listed out the contractor's liabilities. And now this goes against what my professor drummed into me when drafting a contract. You don't say, this is this, this is that. Well, what about if there's in the middle, or actually if it can fit into both definitions? And this is what they've done in the fourth edition. I think it's very unlikely that you'd find something which falls between the cracks or is covered by both, but it is possible, and therefore I ask why, why they've done it. To finish on a good note, 3 good things. In the long forms, I really like this. I really like a greater emphasis on the contractor putting forward the proposals. So rather than the project manager saying, contractor, I want you to put forward a proposal, the contractor off their own back can put forward proposals for whole life costs, value engineering, so savings on capital costs, and acceleration, which in NEC speak means bringing forward to the contractual completion date. I like the prod to use cloud-based NEC3 communication, or NEC communication systems, as they almost hardwire in contractually compliant responses, and they make it easy to administrate the contract, and they also make it absolutely abundantly clear who is not operating the contract and who is. So, and therefore they encourage the operation of it. It's almost NEC project management in a box, all the pro formas generated automatically. If I do this communication and the next one is, it automatically generates it. And I also really like that when not accepting a communication, the project manager or the equivalent in other forms has to state not just the contractual reason for not accepting the communication, but also give sufficient detail to enable the contractor to correct the matter. Now, a good project manager should always have done that under the mutual trust and cooperation one. Here it's stated explicitly that they have to give sufficient detail to enable the contractor to correct the matter. So rather than just saying, I'm not accepting your program because it's not practicable, it's not practical because of this operation here. So with that, those are good, and I'll change over. So my summary, and it's mainly good, predominantly good. The could do betters are mainly tweaks which could have not been done. The one exception to that is I'd like to see a traditional alliance contract. The only one which is potentially ugly is really the option G term contract, dropping that.
Right. Thank you very much, John. Well, We are practically out of time. However, I am told that we can hang on a little bit longer for a couple of questions if people are able to manage that in their day. So we'll carry on with a few questions here. Let's go with this one first here from Mike. Is it possible to contractually make compensation events not for profit?
Right. Okay. So at the moment, how any compensation events are assessed, it's the change in defined cost with reference to the schedule of cost components, etc. And that gives lots of rules on how that defined cost is built up, rather than just saying reasonable cost or something like that. And on top of that is added a fee percentage, which the contractor tenders. All right. And that fee percentage contractually covers anything which is not in defined cost, which essentially means in a construction site, off-site costs and profit. So if you were to say, is it possible to contractually make compensation events not for profit, you would say, what are your head office overheads? And I don't want to see anything in there. And as a result, the contractors might go, well, I don't want to do business with you or whatever. Yeah, but that would be your option.
Okay, so you would basically take it out and say no profit, which is quite allowable under the...
Yeah, I mean, but it's been by commercial agreement before you enter the contract.
Very good. So then the next one is from Hema, and can you give us a little elaboration on how costs are now defined and calculated?
Yeah, so if you're familiar with the schedule, I'll actually cover it as the last thing in the next one is got a couple of slides on the schedule of cost components. But broadly speaking, for the time being, given the timescales, rather than 7 cost headings in the schedule of cost components, which covered effectively cost the contractor was incurring, you now have an 8th one, which is 5th one in order, and that's for subcontract costs. So rather than under options A and B, the price-based options, when a compensation event occurs, assuming that the contractor builds up their costs in exactly the same way as the main contractor, which is a fallacy, you effectively say, under the subcontract, what do you pay the subcontractor? And then the contractor has their fee percentage added on top of that. So if the subcontractor is under an NEC form and they have a fee percentage, it would be fee percentage on fee percentage. Okay? Hope that is enough for the time being. Okay. Listen for part 2.
Yeah. Okay, so we have one more question here regarding fulfilling the BIM, but I believe you covered that a little bit.
Yeah, I mean,
is there anything more you'd like to
say? No, I mean, my criticism of the BIM protocol was not that it was missing anything or anything like that. From what I know of BIM, it covered the relevant points, and it was done by BIM experts, if you like, to cover the relevant points. The problem was that the language used and the order of precedence was completely incompatible with the NEC. So in the NEC, you have a project manager, the ECC. You had, I think it was a BIM manager in the BIM protocol. Well, where do they exist within the NEC? Yeah. How do they relate to the project manager? You had modelling information from memory. Well, how does that relate to, in the NEC3, the works information? Yeah. And you could change what happens if one party didn't deliver that. There was no change mechanism within that BIM protocol. So it's at large, yeah. There's no means of evaluating it contractually. And if you said to one party didn't fulfill it, and you said, now I want you to do something different, because there's no change process, that person could just say, well, the contract doesn't cover change, so I'm going to refuse to do it, or I'm going to hold you to ransom and charge what I like. So that's why I said it was a contractual car crash waiting to happen. The BIM, the information modelling covers those points, if you like, in a contractually compatible way.
Thank you, John. Well, we're now practically 5 minutes over, so I think we need to bring it to the session to a close. I gather there have been some audio problems for some people. We really apologise for that. When we do the recorded event, we will address that and try to make the audio better. And so thank you very much for all the attendees' time on the session. I hope it's been valuable for you. As we mentioned, there will be a second session which is going to be pre-recorded, which will cover the engineering side of things, the engineering and construction contract. Yeah. So that's to be added. So again, once again, thank you very much all, and see you next session.